We start having the considered opinion that it would be neither appropriate nor proper for the court to interfere with the impugned decision in exercise of the writ jurisdiction under Article 226 of the Constitution, particularly having regard to the well settled parameters governing the exercise of jurisdiction in matters relating to the award of public contracts. The writ petition filed by Messrs. G.H. Khandelwal on the subject could not win favor of the Bombay High Court Division Bench at Nagpur, consisting of Justice Urmila Joshi Phadke and Justice Nivedita P. Mehta, has dismissed the petition on April 23, 2026 para. The petitioner has challenged the action of the respondent Amravati Municipal Corporation in respect of e-tender for the maintenance and repair of roads within municipal limits of Amravati, whereby the technical bid submitted by petitioner came to be rejected and the bid of the respondent 4 was found responsive and taken forward for opening of the financial bid para. The petitioner has challenged rejection of its technical bid as well as the consequential acceptance and further processing of the bid of respondent 4 para. The petitioner is a registered partnership firm engaged in execution of civil contracts, particularly road construction, maintenance, and allied infrastructure works. It is duly registered as a Class 4 with the PWD, Amravati State PWD, as well as Amravati Municipal Corporation para. It is the case of the petitioner that it has successfully completed several municipal contracts of similar nature in the past and hold valid works completion certificates issued by the said authority. The respondent 1 issued an e-tender on November 28, 2025 for maintenance and repair of road patches, potholes at various places in Amravati worth about rupees 1.59 crores para. The central controversy revolves around interpretation of clause 3J in Devanagari of the tender condition, which requires the bidder to complete similar work during last 3 financial years of approximate value of rupees 1 crore para. The High Court has pointed out that a plain reading of the clause thus indicates some degree of ambiguity in as much as it does not expressly stipulate whether the value is to be achieved cumulatively or within a single year. However, it is equally well settled that in the matters of tender interpretation, the author of the tender documents is the best judge of its requirement and its interpretation ordinarily be accorded deference as held in Afcons Infrastructure Limited versus Nagpur Metro Rail Corporation Limited and another 2016 SCC 818 paragraph 15 para. The purpose underlining such eligibility criteria I to ensure that the bidder possesses demonstration, technical and financial capacity to execute works of substantial magnitude. Viewed in this context, the interpretation adopted by the respondents that the bidder must demonstrate execution of the work of comparable state within a defined time frame cannot be said to be irrational or arbitrary, even assuming that the clause is capable of a different interpretation as suggested by the petitioner, the court would not be justified in submitting its own interpretation in place of that adopted by the tendering authority, unless interpretation adopted is categorically unreasonable or established by the Malaphite's judicial restraint must prevail. Para. The record further indicates that upon initial scrutiny, the petitioner had not furnished the work done certificate in conformity with the clause 3J. Thereafter, opportunity was granted to the petitioner by the communication of December 10, 2025 to submit the requisite documents. However, upon detailed scrutiny by the tender evaluation committee, around 4 deficiencies were noted.